SJC-12168, Commonwealth v. William M. Ships, Jr.
Are we ready?
Mr. Ships, good morning.
Good morning.
So-
May it please the court, William M. Ships Jr. for the appellant.
Okay, I'm telling you, because you're by telephone, we can hear you, but not perfectly. So try to speak as clearly as you can, if you would. So you may proceed.
Okay. As a non-juror, Robert Catalan's participation in the verdict of this case constitutes a fatal jurisdictional defect that renders those proceedings coram non judice and void. This is a threshold jurisdictional defect that subsumes and subordinates the other appellate issues in this case. In fact, this court's very own appellate authority is affected by Robert Catalan's unlawful verdicts. The session clerk, Edward Sheehan, individually polled Mr. Catalan for his separate and distinct verdicts, each time calling Robert Catalan by name and each time receiving an individual response and verdict from Robert Catalan. These polling colloquies, questions and answers between Robert Catalan and the clerk were recorded verbatim as they occurred in real time by an official court stenographer, Mr. Arthur E. Baker. In addition to being an official court stenographer and a neutral court official, Mr. Baker was also a leader in the field of court reporting as a former president of the Massachusetts Court Reporters Association. As duly taken, prepared, and verified by the official court stenographer for this case, Mr. Baker's certified transcript, including Robert Catalan's unlawful verdicts, constitutes the official record of those proceedings. This point is well settled by the provisions of General Laws, Chapter 233, subsection 80, and by this court's very own decision in 2013 in Commonwealth versus Winfield. Further, because this certified transcript is recognized by statute and by decision of this court as the official record of those proceedings, changing that official record at this point, post-appeal, becomes a dubious prospect for several reasons. First, there is no rule or authority that authorizes changing the official record of a case following direct appeal. In fact, in Hamad versus Fadili, F-A-D-I-L-I, this court explicitly rejected an attempt to change the official record of a case after the direct appeal of that case had been decided. And if I may briefly quote, the court stated, "It is implicit in the rule and the very nature of the appellate process that any correction to the record must take place before the appeal has been decided. Therefore, the trial judge could not amend the record in this case after the decision of the appeals court. This rule is necessary to preserve the integrity of the appellate process," end quote. As I previously stated, changing the official record of this case at this point becomes a dubious prospect. Second, even if it was somehow acceptable to change the official record of this case at this point, what quantum of proof would be required to change that official record, to change that official transcript? Because the certified transcript of an official court stenographer is recognized by statute and by decision of this court as being the official record of those proceedings, I would suggest that vitiating that certification of that official court stenographer and changing that official transcript ought to require a substantial quantum of proof, perhaps even proof beyond a reasonable doubt that the transcript is not accurate. In the present case, however, the Commonwealth has offered only speculation and conjecture and self-serving surmise for proof of its contention. The inadequacy of the Commonwealth's proof is addressed in the appellant's brief. For example, the Commonwealth's position is that because the verdicts were returned at 5:45 p.m. during a Saturday court session, that Mr. Baker was somehow impaired or incapable of performing his stenographic duties, and simply proceeded to enter into the official record specific conversations that were not really taking place. There's absolutely no evidence that Mr. Baker was impaired, as the Commonwealth suggests.
Mr. Ships, could I just interrupt you for a moment, please? Just ask if we could just go to another issue just for a moment. If the single justice had had a transcript of the motion for a new trial, what impact are you saying that could have?
Pardon me, I could not hear your question, Your Honor.
My fault. If Justice Spina, a single justice, had had a transcript of the hearing on the motion for new trial, how would that have assisted him?
The single justice
Right.
and the motion to stay is at this point, it becomes a subordinate issue in this appeal. The transcript of the Superior Court hearing, which I was seeking to prepare my gatekeeper petition, it still hasn't been produced. But that wasn't the be-all and end-all purpose of my motion to stay. As you're well aware, a gatekeeper petition must be filed within 30 days of the Superior Court's decision. It's a very short period, and often materials are not fully gathered and compiled for preparation. I requested a stay of the gatekeeper proceedings in order to compose a proper gatekeeper petition. I filed a 2-page petition as a procedural filing because such a petition must be filed. I believe a stay of that petition was warranted, and I requested it. The single justice never ruled on my motion to stay. Several months later, it was several months later, I got the notice that the petition had simply been denied. And I believe there was other ways of handling that weren't as fundamentally unfair. But moving back to where we are at this point, jurisdiction is a threshold matter at this point. If Mr. Catalan was truly there, as the record indicates he was, then all of the proceedings that have occurred since that point were undertaken without competent jurisdiction, and that includes the gatekeeper petition. Now, I addressed these issues in my briefs, and in particular through a case, Donnelly versus Montague. Donnelly versus Montague clearly indicates that an appellate court cannot exercise any jurisdiction that was not possessed by the court below. If Mr. Catalan's presence and participation in those verdicts vitiated and caused a jurisdictional defect, then that's where jurisdiction stopped. The fact that no one at trial and no one reviewing the trial record, including the full Supreme Judicial Court, ever realized that Mr. Catalan was present doesn't mean it's a transcription error, as the Commonwealth would argue. It means that everybody missed him. And to miss him in a first-degree murder case, to miss an unlawful invader delivering 2 first-degree murder verdicts it's not a transcription error, it's a failure of our justice system. But more importantly, for the present circumstances, it's a jurisdictional defect. It's a defect that can never be waived, it can never be forfeited, and a defect which this court has a duty to adjudicate before proceeding to the subordinate issues of this appeal. As I mentioned, this court's opinion in Donnelly versus Montague, as discussed in the appellate's brief, it provides a cogent explanation for why jurisdiction is properly before this court now as the threshold matter. I address all of this in my briefs, and
I'm afraid, Mr. Shipp, your time is up, Mr. Shipp, so
thank you.
thank you so much. Ms. Grant, do you wish to be heard?
Good morning, Marguerite Grant, Assistant District Attorney from Norfolk County on behalf of the Commonwealth. I want to apologize to the court. There's an error in my brief. At page 3, note 2, I stated that the defendant was 16 years old when in fact he was 17 years old at the time of the crimes. That doesn't change the legal analysis, and it is correct in this court's opinion on direct appeal, which is in volume 399 of the Mass Reports at page 5. Just briefly, I want to say that as far as the underlying issue of error in the transcript, there's contradictory facts stated in the transcript. As the defendant explained, in the polling of the jury, it states the name of the so-called 13th juror. That's at pages 127 and 131 of the record appendix. Contradictory facts to that is that when those jurors came into the courtroom to render their verdicts, the clerk announced that there were 12 of them. That's at page 121 of the record appendix. In addition, the transcript from the day before, the Friday when the alternates were chosen, shows that 3 alternates were chosen and 12 jurors were chosen. That's at page 164 of the record appendix. So those propositions can't both be true, both that this 13th juror was there and that there were 12 jurors. And Judge Connors, in ruling on the motion for post-conviction relief, although he was not the trial judge, did not abuse his discretion. And as far as the issue before the single justice on the motion to stay the appeal or the gatekeeper proceedings, he did delay about 8 months in acting on the gatekeeper petition, but he properly, in declining to rule on the motion for stay, he effectively denied it, and he properly did so because a transcript of the non-evidentiary hearing before Judge Connors, who was not the trial judge, would not have a realistic possibility of changing the outcome of the single justice's ruling. Unless the court has any other questions, I will rest on the Commonwealth's brief.
All right, thank you.